All right. Welcome, everybody. My name is Dana Sparks. I am the director of the Georgia Real Estate Academy. I am also the qualifying broker of Maximum One Greater Atlanta Realtors. The only reason I tell you that is because today's class has to do with contracts and contract tips. So I wanted to give you a little bit of context as to my current interaction with the contracts. Now, I'm not the compliance broker of our firm. We have a compliance broker that sees every single contract. I am the managing broker, so I just see contracts that have the qualifying broker and the managing broker. So I just see contracts that have issues. So, just a couple every now and then. I also teach classes and manage the company, but I do see contracts on a regular basis. And so I am keenly aware of what you as an agent are facing in today's market. This is spring 2022. It is a very fast, y'all see my air quotes, a very fast market in the Atlanta area, Atlanta metro area. What that means is there are more buyers than sellers out there. So there are a lot of strategies that buyers are using in a competitive offer situation, so forth and so on. So I just wanted to let you know I am keenly aware of the excitement that you as agents are facing in today's market on both sides, the listing side and the buyer side. So we are going to get started. I do have, this is a PowerPoint presentation. There are handouts available to you. You do not need them for this class, but they are available to you to download for reference. Everything that is, I just put in the chat function where you can download the handouts. Again, I'm going to cover everything in this class, so all you have to do is pay attention, but they are available for you after class as a reference. And you'll see all the forms that I have available to you are all underlined with notes and all of that stuff. So everything will be hopefully done for you. This class is the 2022 GAR, Georgia Association of Realtors, Brokerage Agreements and Other Useful Forms and Special Stipulations. It is a course for continuing education credit for your Georgia real estate license. If you are attending this class and hold a real estate license in another state, you will have to check with your real estate commission there if this class will serve as continuing education for that license. But it does serve as 3 hours of CE credit for your Georgia license. And I am going to share my screen. We are going to start. If you do have any questions, please type them in the chat. And here we go. So welcome, welcome. Let me get rid of this. And let me put on this slideshow from current slide. All right. Here we go. Let me make sure. All right, 2022 GAR, Georgia Association of Realtors, Brokerage Agreements and Other Useful Forms and Special Stipulations, GREC course number 73907. The intent of this course is to cover forms available to you that are not typically covered in depth in a regular contracts class. So I'll tell you what we're not going to talk about. We are not going to talk about the purchase and sale agreement. We are not going to talk about the loan contingency agreements. We are going to talk about the brokerage agreements and some of the other forms. This could go on and on and on and on, but I am limiting it to 3 hours. This is the notice to students. It is offered through the Georgia Real Estate Academy, GREC School 6915, with an end date of having to renew the end of this year. It is GREC course number 73907. This is a remote broadcast of an approved in-class course, 3 hours in duration, approved by GREC for CE credit, no prerequisites. You may only take one virtual CE class at a time or with overlapping times, regardless of the school offering the course, in order to get CE credit for either course. I'm your instructor. Again, my name is Dana Sparks. I am the qualifying broker of Maximum One Greater Atlanta Realtors. I am also the director of the Georgia Real Estate Academy. No homework, no written exam. You must be on time and present for all remote virtual broadcast instruction hours in order to receive credit. Roll call and documentation of your license number will be conducted via the chat function. We do this at the beginning, so if you have not already done so, please type in your name, license number, and email address. When we get back from the break, do that again, and then right before you leave. So there are 3 times that you will need to type that information in the chat function. You may only get credit for any specific course number once every 12 months. If you've already, I know you haven't received credit for this course because this, I believe, is the first time we have offered it. But if you have, you're more than welcome to stay, but you won't get CE credit. No recruiting for employment opportunities for any real estate brokerage firm is allowed in this class or on the school premises. If so, report to myself or Heidi Kelly, who is the coordinator of our school, and there is her contact information, or the Georgia Real Estate Academy directly. All right. Notes about this class. The purpose of this class is to bring your attention to the plethora of contract forms. There are a lot of contract forms available to you through the Georgia Association of Realtors. GAR has been providing contract forms for real estate agents in the state for at least over 30 years. I know I have been practicing over 27 years. I currently do not practice. I am what's considered a non-competing broker, meaning I just teach, manage, and interact with agents, but I don't actually buy or sell, help the public buy or sell anymore. So, but when I did practice, I have had my license for over 27 years, and I know the GAR contracts were available when I began practice, again, 27 years ago. So they have been in existence for a long time. And what GAR does is they just continually add to their library as well as making changes. GAR makes changes every January of every year, and then they do a mid-year revision, which they just released the mid-year revision May 1st, 2022. So we will discuss a couple of those issues as well. To cover all of these forms in depth would require way more than 3 hours. Generally speaking, any CE class you take, make sure to confirm any specific questions with your own broker and with respect to your brokerage's policies and procedures. Again, there are handouts available to you as a reference. You do not need them as we go through the class, but that is where you can get them. All right. We are just going to dive in. So in Georgia, if you do have any questions, y'all type them in the chat. I will repeat them out loud and answer them. So in Georgia, the client relationship is created contractually. So in other words, your public person must sign a document in order to be considered a client of your broker. And just note that when I say you, meaning you as the affiliated licensee or your broker, I am using those terms interchangeably because you guys are all affiliated licensees with your broker. All contracts belong to your broker or in the name of your broker, and all business is done in the name of your broker. GAR, even in the purchase and sale agreement, does define broker to mean the actual qualifying broker, the person, or the brokerage, or you as the affiliated licensee. Now, there are a few differences if it is a dual agency situation or a designated agency situation. But other than that, those terms are synonymous in terms of the forms and the responsibilities and consequences when you are signing forms. So in order to create a client relationship with the brokerage, the public person must sign a brokerage agreement, regardless of your personal relationship or past relationship with them. So for a seller, it's GAR F101, which is the exclusive seller brokerage agreement, or F104, the non-exclusive seller brokerage agreement. So just because it's a non-exclusive seller brokerage agreement, it still creates the client relationship between that public seller and your broker. And on the buyer side, F110, the exclusive buyer brokerage, and F113, non-exclusive. Now, if you're working with a public person as a customer, there are no laws in Georgia that require that they sign any documentation. However, your broker may have a policy, and regardless of your broker's policy, you guys are all independent contractors. I strongly suggest that if there is an opportunity to disclose information to the public with respect to a real estate transaction, that you get that documentation into their hands so that you can demonstrate you did provide them with something that did explain their relationship to you and your broker. So these are available to you in the GAR contract package. There is a customer acknowledgement that describes the customer relationship. By default, if a public person doesn't sign a brokerage agreement, they are a customer, but these documents describe it. There is the F107, which is the authorization to show unlisted property, which describes the customer relationship for a public seller, and the F116, which is the document agreement to work with buyer as a customer that describes the customer relationship between the public buyer and your broker. There are additional forms related to the brokerage agreements. There is F728, amendment to a brokerage agreement. There is a mutual termination of a brokerage agreement, unilateral termination of a brokerage agreement, and a notice to extend a brokerage agreement. So the amendment to the brokerage agreement, you would use that for either a seller brokerage agreement or a buyer brokerage. So that would be something to the effect of if you are going to change a sale price, a listing price, sorry, not a sale price, but a listing price. If you are going to extend the time frame, if you are going to change up the commission, you would do that on an amendment to brokerage agreement. Mutual termination is just what it says, a termination between your public client and your broker. Unilateral termination is used if your client wants to terminate the client relationship, or if you as the broker / agent want to terminate the brokerage agreement. And there's differences in those. I'm going to cover those. And then again, notice to extend the brokerage agreement. We are going to talk about earnest money forms. They will be, more of the earnest money forms are discussed in depth we have another class that we offer that is the 2022 Georgia Association of Realtors Contract Dissection CE class. So I believe there's a couple that I touch on, but I'm not going to talk about those in depth. Those are fairly addressed pretty much in depth in several contracts classes, but they are, just for your information, the F510, closing attorney to act as holder of earnest money exhibit, which is part of the purchase and sale agreement that the buyer and seller sign. Then there is the F511, agreement of closing attorney to act as holder of the earnest money. That is a document that comes after the parties are binding, that only the closing attorney signs. F522, unilateral termination and release. 519, mutual termination and release. And F290, agreement to reinstate contract. There are some contingency exhibits that we will discuss. F601, sale or lease of buyer's property, meaning they have to sell or lease their current property and they're making their purchase contingent upon that happening. Backup agreement and a general contingency exhibit. I will tell you guys at the break where you can access our calendar. We do teach the GAR contract dissection class on a fairly regular basis, in addition to license law and ethics. All right, special stipulations. You definitely need to check in with your broker prior to using any special stipulation that you learn in any class. Just because it sounds like a good idea and makes sense to you and fits your particular scenario in any given transaction, you are an affiliated licensee of your broker, and you definitely want to make sure that you have your broker's permission to use any special stipulation. Also in the GAR contracts, just so you know, in the purchase and sale agreement that we're not talking about today, there is a section in there where the party, the buyer or the seller, whomever you represent, does, when they sign the purchase and sale agreement, they do acknowledge that any special stipulation that you write is that they understand it, and they understand that it is in their behalf, and they agree to that as a special stipulation. But there are a lot of special stipulations, and we are going to cover some of these towards the end of class. The infamous appraisal gap stipulation, an escalation clause stipulation, lots of stipulations having to do with buyers and sellers negotiating for repairs. There is a special stipulation for a complex to be approved for an FHA or VA loan. You buyer's agents, if you guys are helping buyers purchase a home, especially in a condominium association, you absolutely need to protect that buyer's earnest money. Not all condo associations, townhouse associations are approved for a buyer to get an FHA or VA loan. And unless you have this special stipulation in there, that might not be a reason. Well, it's going to be a reason for your buyer to terminate or have to switch loans, but that might not protect their earnest money unless you make the contract contingent upon that. I'm going to talk about a special stipulation for a conformed copy or a clean copy of a contract, home warranties, property disclosure requests, termite letters, so forth and so on. Amendments that we're going to cover, amendment to address concerns, amendment to change closing and possession date, unilateral extension when and if it can be used in any particular contract, amendment to sale price, general amendment, and binding agreement date confirmation amendment, which is a brand new amendment that GAR has released January 1, 2022. Tons of miscellaneous forms that we're going to cover. Temporary occupancy agreement for a seller after closing, instructions to closing attorney, notice to withdraw an offer, notice to reject an offer, request for confirmation of presentation of offer, reminder of important dates, vendor list, broker information disclosure, net to seller, buyer cash to close, notice, and notice to extend brokerage agreement. All right, that's sort of an outline of what my goal is in this class. My other goal and my primary goal when I teach classes, and I see I have a lot of familiar faces, so welcome friends, I appreciate your coming back. And I see a lot of new faces. If you are new to any one of my classes, welcome. I hope you enjoy it. I hope you have a good experience. I absolutely love teaching CE classes and teaching in general, teaching contracts specifically. My goal as an instructor is that at the end of the 3 hours, you're like, oh my gosh, the time went by so quickly. I learned so much, and the 3-hour CE credit is just a bonus. My other goal in the way that I teach CE classes and my approach to education and learning is that I like teaching things in a way that you as the agent can really connect with the information and understand it, so that if you're in the middle of a contract or in the middle of a situation, you cannot get a broker, you cannot get a more experienced agent, you cannot get an agent who's dealt with the situation before. You will be armed with the information to think through an issue after going through this class, so you'll know when a form is appropriate or not appropriate, when a special stipulation is appropriate, when you receive a special stipulation, if your client should accept it or if you should counter, that you can think through these based on how I teach. I like to teach conceptually so you guys understand what's going on and how to protect your license and your client or customer. So again, brokerage relationships, a broker may work with the public either as a client or as a customer. A client is also referred to as having an agency relationship, and as I mentioned at the beginning, is contractually created in Georgia. Seller can be a client or a customer. Buyers can be a client or a customer. This is why I said that in Georgia it is legally created. You guys, regardless of what I say or any instructor says in any class, you need to back it up. You need to find out where or why they are saying what they are saying. So I'm saying, so for example, when I say that the client relationship is contractually created in Georgia, there are a lot of brokers and agents that mistakenly think that if they are working with a past client in a new contract, that they have a client relationship with that person. That's not the case. Georgia, based on our Beretta laws, state that a broker who performs brokerage services for a client or customer shall owe the client or customer only the duties and obligations set forth in this chapter, meaning this chapter of the law, Title 10, Chapter 6, unless the parties agree otherwise in writing. A broker shall not be deemed to have a fiduciary relationship with any party or fiduciary obligations to any party, but shall only be responsible for exercising reasonable care in the discharge of its specified duties as provided in this chapter, and in the case of a client as specified in the brokerage agreement. And so again, just because you might know everything about a past client, their portfolio, what they like to purchase, what they like to sell, so forth and so on, in any transactions, they have to sign a brokerage agreement in order to be considered a client. Now, that doesn't mean that you should, if you're working with a past client in a contract, you probably should disclose that as a material relationship, that they are a past client of yours. But any transaction is based on if they've signed a brokerage agreement. So seller agency is the client relationship with the seller. Buyer agency is the client relationship with the buyer. Designated agency means there's one broker, two agents, and each agent or the broker has a client relationship with both the buyer and the seller. In other words, seller signed a seller brokerage agreement, buyer signed a buyer brokerage agreement, but they are working with two separate agents within one brokerage. Dual agency, one broker, one agent, client relationship with both the buyer and the seller. Dual agency, I cover this more in depth. Dual agency is not illegal. However, it must be disclosed in writing and the public parties must consent, and you must check with your brokerage. A lot of brokerages have a policy prohibiting their agents or their brokerage from practicing dual agency. License law requires signatures on a brokerage agreement if the broker is working with a public as a client. So not only is that written in our Beretta laws, but it is an unfair trade practice, OCGA 434025B. And as I mentioned at the beginning, there's no law required to sign anything if you're working with the public as a customer. However, as I've already mentioned, definitely a good idea for the public, for your license, for your broker, to have the public sign a document that describes their relationship. And again, I'm belaboring this point a little bit. Agreement creates the client relationship, is the exclusive, and the agree with the seller, and the agreement that describes the customer relationship is authorization to show unlisted property. And as I mentioned, the non-exclusive seller agreement also. For the buyer side, the agreement that creates the client relationship is the exclusive buyer brokerage, the form, and the non-exclusive, and the form that describes the customer relationship is the agreement to work with buyer as a customer. All right, we are going to dive into the seller brokerage agreement. This is not going to be a line by line fill in the blank seller brokerage agreement class, because we have way too much information to cover with all of the forms. So I'm just going to hit the highlights and just point out to you what you need to know. So there are a couple of different dates in the seller brokerage agreement. So this is sort of an outline of what we're going to discuss. I'm going to dive into each one of these and show you guys where you can find it in the actual form itself. There's a commencement date, marketing date. There's commission. There are 3 parts to commission: co-op commission, commission adjustment, separate commission on a lease, protected period, disclosure statements, and seller default. On the exclusive seller brokerage agreement, and this is the same with the non-exclusive, there are fill in the blanks for the address, legal description, list price, so forth and so on. It talks about the client relationship, marketing commencement date, the MLS services, commission, protected period, and what is allowed or not allowed. I'm kind of glossing over that. That's sort of like an outline of what to expect for this next section. Here in Metro Atlanta, Metro Georgia, an address is not a sufficient legal description. There are more than one Peachtree roads in Atlanta, in the Atlanta area. Therefore, there's more than 1, 2, 3 Peachtree roads. It's very easy to get confused if it's Peachtree Road, Peachtree Boulevard, Peachtree Court, Peachtree Avenue, Peachtree Circle, Peachtree Court, Peachtree Lane. So you definitely will want to have a legal description in addition to a property address. If you do not have all the information, then you'll want to reference the warranty deed book and page. And what I mean by that is, you guys have all seen where it says landlocked district section, GSM, lot block, all that stuff. If you don't just fill that out partially, if you cannot fill out every single blank in that, then it's better to just reference the warranty deed book and page. There are lots of places where you can get the legal description: your online county records, gsccca.org, or your favorite closing attorney. In the seller brokerage agreement, there is a separate section if it is condominium ownership versus fee simple ownership. You guys, condominium refers to ownership. So let's get a little interaction going in the chat versus fee simple. So if a property is conveyed, if the ownership of a property is via condominium ownership, a lot of the public, and actually, frankly, a lot of agents refer to a condo or condominium meaning a style, meaning typically they mean attached housing. And a townhouse, they typically refer to as 2-story attached. But in reality, condominium refers to ownership. So in the chat, I want you guys to type, if an owner owns a property via condominium ownership versus fee simple ownership, what do they own? Type it in the chat. What are your thoughts? What do they own if they own a property via condominium ownership? What are your thoughts? What does a person own if you own a condo, if your title is condominium ownership of a property? Space from the inside drywall in. Residential attached describes it, but it's not what they own. Come on, you guys, I need y'all to interact so I can prove that you didn't just turn on the computer and walk away. Partial ownership of a larger association. All right. So if somebody owns a property with condominium ownership, they own the insides. They do not own the outside. They have shared ownership of the outside. So they own the inside all themselves, the outside, the roof, the exterior, and typically the common areas, they own in conjunction or in common with every other property owner within that complex. Fee simple ownership, they own everything, the inside and the outside. So it gets a bit complicated when you have an attached property with fee simple ownership, which you do. Townhouses and one level properties that are attached, they can be condominium ownership or they can be fee simple ownership. So it does get a little tricky if I own an attached property fee simple. That means I only own my portion of the roof. But what if a storm comes along and the whole roof on the whole building gets damaged? So it can be a bit tricky, but again, condominium refers to ownership, not style, not one level, one story versus two stories, and not attached or not attached. All right, now let's dive into the two time periods. You fill in the list price, and then there is a commencement date and an expiration date is required by law. So you must fill in the commencement date. That is the date that actually starts the client relationship. And per license law, you must put in an end date. However, there is another date referenced in your seller brokerage agreements, and it has to do with marketing the property. There is a, oh, do I not have it? Shoot, hang on. I don't have this one thing in the slide. So let me show you guys where this is. I apologize. I thought I had this one little copy and paste from the, oh, shoot. Wrong thing. All right. Well, I'll show you here. Here is, okay, I do have it. All right, forget it. It was just not where I was expecting it. All right, let me go back to the slideshow. All right, now I've lost it. There we go. From current slide. All right. So the commencement date starts the client relationship. Now, the next section is here. You have a place where you fill in marketing. Broker agrees to file this listing with the following multiple listing services, and you would identify the listing services where your broker is a member or you are a member. Now, this section where it has delivery of agreement to and listing with the MLS, this agreement must be timely delivered and listed with the above referenced multiple listing services in accordance with the rules of such MLS service. This obligation shall control over any conflicting or any inconsistent language herein. I'll explain what that means in a second. And then there is a marketing commencement date. The marketing commencement date may be the same date as the commencement date of the brokerage agreement, or it could be different. So now let me back up a slide and go over this just a little bit differently. So what this says is the listing must go in the MLS service per their membership rules. For example, FMLS's rules state that a listing must be entered into the listing within 2 business days. Regardless if 2 business days if it's in coming soon status, or 1 business day if it is immediately active. The marketing commencement date is the date the property is marketed to the public. In your brokerage agreement, the commencement date relates to the status that the marketing date is relates to the status the property is entered into MLS. If the commencement date and the marketing date are the same, you enter it in as active. If the commencement date is prior to the marketing date, you enter it in as coming soon. What does all of this mean? So again, this is one date. This is the date that starts the relationship. If you are going to start marketing the property and put it in the MLS on the same date, then you enter it into the MLS service as an active agreement. If you're going to start the client relationship today, but your seller doesn't want it on the market until next Monday, 2 weeks from now, whenever, then your marketing commencement date is different. However, per your MLS service, you are still required to enter it into the MLS service in FMLS's situation within 2 business days after the client signs the commencement date. If the marketing commencement date is later, then the status is coming soon. Coming soon may not be shown to anybody. The public may not see a property listed as coming soon. A co-op agent may not see a property listed as coming soon. Your agents in your own office or agents in any other office may only see information regarding a coming soon listing via the information that you provide to them on the MLS service, but it cannot be seen in person. If the commencement date, so that's what I have there. All right, now let me show you where it talks about commission. This is the section on commission. It's paragraph 4. Again, we're on the seller brokerage agreement. You have a place where the seller agrees to pay the total commission when the transaction closes. And that can be expressed as a % of the sale price, a flat fee, or anything else. Then the listing broker or the seller's broker agrees to pay a cooperating broker, if there is one, a certain percentage. So this number in section 4B should be a smaller amount, a smaller percentage than this. So if you have 10%, for example, commission in A, B needs to be a number less than 10, or else the seller's broker is working for $0. Here is another section where it talks about commission adjustment to a cooperating broker, and another section where it talks about separate commission on a lease. So the total commission is written, and then again, a portion shared with a co-op broker. The commission adjustment, that is talks about circumstances under which a co-op commission may be different than what you advertise in the MLS service. For example, you guys have all seen this in your practice. You will see a property in an MLS service. It has an amount for a co-op commission that if you're working with a buyer and you're the procuring cause of sale, it will say the co-op commission will be X amount percentage of the sale price. Then in the private remarks section, it might say something to the effect of, if buyer's broker is not present at the time of first showing, then the buyer's broker's commission shall be Y% of the sale price. So that would be in the private remarks of the MLS, but the seller has to agree to that. It's the seller's money. The seller has to agree to that. So the seller, what's written in a private remark in an MLS service must be backed up on the listing agreement or seller brokerage agreement. And in GAR, here's where it is: commission adjustment to cooperating broker. There may be circumstances where the seller's broker shall not pay the cooperating broker the amount referenced up here above. This is what that circumstance is. Then there is written out separate commission on a lease. We have a lot of sellers, not necessarily right now, but in other markets, and maybe right now, where a seller puts a property up for sale, but they end up not selling it, and in turn end up actually leasing it or signing a lease purchase agreement. So what this section says is, if the seller ends up leasing a property, then the seller owes commission on the lease in addition to the commission on a sale. So for example, if you're working with a seller and they end up accepting a lease purchase agreement, the seller would be obligated, if this is filled out and disclosed, on the closing of the lease purchase, and then another commission on the closing of the sale. And that's where it says you fill out the circumstances under the lease, And at the very bottom, it says this agreement does not relieve the seller from paying commission at the closing of a contract to sell. And then you have the protected period, because what are you protecting? You're protecting your commission. Now, the next section in the listing agreement, paragraph 6, talks about agency and brokerage. And we've talked about this pretty in depth already at the beginning of this class. You do describe the agency relationship that is not offered by the broker. If there is dual agency and your broker offers it, there is double disclosure in GAR. GAR is absolutely protecting you, protecting your broker, and protecting your public. Again, you need to check if it is acceptable in your broker's policies, but it is legal if it's disclosed in writing, agreed to in writing by both sides. It should be sides, not sided. And the broker may have a policy against it. And here's where it talks about that in the actual seller brokerage agreement. This verbiage is repeated in your purchase and sale agreements just for double protection for everybody involved. Now, I often get the question, well, what about having both sides? Can I have both sides of a contract without it being dual agency? You need to check with your broker's policies, but from a contract standpoint, yes. Remember, we talked about what creates agency, what creates a client relationship, and what describes a customer relationship. So as long as your broker allows it, you may have both sides of a contract. It is not dual agency if one or the other is a customer. You run into this all the time. Let's say you have a seller that has signed a seller brokerage agreement, you have it listed, you get a sign call on it, you show that buyer, the buyer says, I'm not really wild about that property. You say, great, I've got access to every other property for sale. You sign a buyer brokerage agreement with that buyer, you show them other properties, they come back to you and they're like, you know what, Dana, funny thing, the very first property, I've been thinking about that and I think I want to buy that. Well, now you have a client relationship signed with the seller and a client relationship signed with the buyer. So that would put you in a precarious situation, but that would be dual agency if you continued those relationships with the parties and went on in a contract. But if you have a listing for sale, a listing, and you've signed a seller brokerage agreement, you get a sign call, the buyer wants to buy it, that buyer is a customer. So you can have both sides where you have a client relationship with one and not with the other. Or let's say you're working with the buyer, you've signed a buyer brokerage agreement with them and they want to buy it for sale by owner. Now you have a client relationship with the buyer, but a customer relationship with the seller. Or also what I'm seeing right now a lot is we have a lot of sellers that have rental properties and the tenant has approached the seller and wants to buy the property that they have been renting. They come to you and want you to write up the deal. Well, you could sign you don't have to sign anything, but you could use authorization to show unlisted property with the seller, customer acknowledgement with the buyer, and you can act as a transaction broker, a true transaction broker, and have a customer relationship with both sides. So there are many situations where you can have both sides of a deal with it not being dual agency. My advice to you as a broker and as an instructor, if you have both sides of a deal, the party or parties with whom you do not have an agency relationship, absolutely you want to get them to sign the customer acknowledgement, but you definitely will want to be able to demonstrate, should you be called up in a GREC investigation, an ethics investigation, an arbitrator, or a judge, you want to be able to demonstrate that you did have the discussion with them, the difference between being a client and a customer, and you did offer them agency relationship. And you can do that with another referral to another agent. It can be another agent in your brokerage, which would be designated agency, or to another broker. You'll want to get with your broker how to walk through that. But I promise you, you will be better protected and your license, to protect your license and protect your broker if you at least can demonstrate that you had that discussion with the public person. All right, special circumstances. There is a section in the brokerage agreement where it talks about special circumstances, bankruptcy, divorce, short sale, so forth and so on. You don't need to fill that out. We have a lot of agents that are working with a divorced couple and will mark this section. That's not appropriate if the couple is already divorced and let's say they have a court order to have to sell the house and divide up the proceeds, or even not a court order, they've just decided that in the divorce. You only fill this section out if the sale of the property requires third-party signatures. In other words, let's say the couple is in the middle of a divorce, and typically it would be a divorce that's not quite so amicable, and the divorce court says, okay, I am requiring that you sell the property, and I have to sign off on the purchase and sale agreement or on the listing agreement, the judge would, because sometimes you'll have a situation where one party might be on title to the property. It could be a divorce, and the party that's on title says, you know what, fine, you get half the proceeds. Well, guess what? I'm going to sell it for $20,000. So again, it depends on what's in a divorce decree or an ongoing divorce or bankruptcy, so forth and so on. But you only fill this out if the bankruptcy court or the divorce court is required to give their signatory approval of a listing or of a sale. So just if it's already a done deal, those don't need to be completed. All right, there is a section where it talks about further explanations in the seller brokerage agreement. And it talks about in an exclusive agreement, the seller says, the public seller says, when I sign this agreement, I am stating that I am not a party to any other seller brokerage agreement, and I have not terminated a previous brokerage agreement without the consent of a broker. I'll talk about this a little bit more in depth. This is contained in the buyer brokerage agreement, and we see this more with buyers than with sellers. But basically, this is if a public person, quote unquote, fires their agent or fires their broker. They are stating that they are not subject to another brokerage agreement. Again, with a seller side, it's a little bit easier to see with an MLS service, but I'm going to talk about that a little bit more because it's more prevalent with buyers coming to you saying, I need your help buying a house. And you ask them, well, are you currently working with an agent? No, I fired my previous agent. Well, what does that mean? What are the ramifications of that? That's what this section is talking about, and I'll talk about that later. List price. There is a section in the listing agreement where it says if a property does not get shown or you do not get a contract, the price may be too high. Not necessarily being experienced in this market. Actually, some are starting to get that in this market, but definitely as the market cycles and where it twists to more, there are more an equitable number of buyers and sellers, or there tend to be more buyers than sellers. A lot of times a seller might list the property too high. Listing period. Now, this verbiage in the seller brokerage agreement, it states that the listing period is automatically extended under these certain circumstances. If you are working with a seller, you've got a listing agreement and the property goes under contract, but that contract fails to close. In other words, you go under contract with a buyer and they end up terminating for whatever reason, due diligence or whatever contingency, but you were under contract, let's say for 10 days, and then it terminated, you put it back on the market. Those 10 days, the time frame that it was under contract but didn't close, automatically get extended to the end of your listing agreement. However, you as the agent must send notice to that seller within 5 days of that terminated contract. If you don't do that, then it doesn't get extended. Here is where it talks about that under extension. It talks about if you are under contract, but it fails to close, the contract period is automatically, this is the bottom part, is automatically extended. But you as the agent, you need to send notice to that seller 5 days after the first buyer bailed on whatever contingency, or else that extension does not go in place. This part up here, section 2B, states that the listing agreement is automatically extended through closing. So what that means, let me go back and see if I missed anything. Okay, before I go to that. So if you're under contract, terminates, and those time frame is extended, here's the notice that you as the agent use to extend that agreement. It is GAR F-158, notice to extend brokerage agreement. It is a notice, so they don't have to sign it. They've already agreed to that in the listing brokerage agreement. So only you as the broker or you as the affiliate licensee or your broker sign it. And you do need to fill that in within 5 days of a termination of a contract. But here's the other part. Let's say your listing agreement expires. Let's say your listing agreement for whatever reason expires today, but you're already under contract and the closing isn't for another week. You don't need to sign an extension in that behalf. This states that the listing agreement, the brokerage agreement, is intact through automatically, this is paragraph 2B, automatically extended through the closing of a contract if you're already under contract. All right, this next section, this paragraph 3 on marketing, multiple listing services, lock boxes, all of this information, no marketing by seller. Basically what all of that says is the broker does not have control over all of the marketing. We don't have control over how it looks in Zillow, Trulia, Realtor.com, so forth and so on. We do have control over how you put it in the MLS service and your own website and your broker's website, but these third-party vendors, we don't have control over that. It also goes on to say that any photos or videos purchased or taken by the broker belong to the broker. If they are taken or paid for by the seller, they belong to the seller. The seller agrees not to market or advertise the property on their own without permission of the broker. The seller acknowledges that others may take photos or videos. In other words, especially nowadays, we have a lot of buyer's agents that might, quote unquote, show a property virtually. In other words, it might be just the agent that walks into a property and has their camera or their cell phone and they walk through and do a running commentary showing the house via video, or buyers themselves might take photos and the seller acknowledges that others might do that. Here is a thing I want you to think about. If you are a buyer's agent and you are doing that, you are virtually showing a property to a buyer who is not physically with you. Or if you are showing a property and the buyer is physically with you and they are taking photos or video of the house. You need to do this simply as help for showing a property or a reminder. You as the agent do not have permission to put that video or put those photos online. You do not have that seller's permission to post that on Facebook, post that on a YouTube video, post that anywhere else. Your buyer also does not have permission to post that walkthrough video on YouTube or Instagram or Facebook and say, look, everybody, this is the house I just wrote an offer on. So do buyers do it? Yes. Do agents do it? Yes. Just know you as the agent, there may be consequences against your license because license law states that you must have the seller or seller's agent, authorized agent's written permission to market a property. So just be careful. Broker to put in the reference MLS services to begin when marketing begins. We've already talked about that. Seller agree. There's also a thing in the listing agreement where it says the seller agrees to remove or secure all valuables and prescription drugs. All of that is written out here. And the section on commission, which is this part right here, It says that the seller is obligated to pay a commission at closing. The listing broker will share the commission with the buyer's broker, and the seller to pay the commission upon the lease. Everything, all the fill in the blanks. This is all the legalese describing all of that. Now, protected period. I need to just describe this just a little bit because a lot of agents misunderstand what a protection period means in a seller agreement. The protected period. Type in the chat. What are you guys putting in for protected period on a listing? What is the time frame in the fill in the blank that you are filling in for this protected period? Give me some ideas of what you guys are putting in your listing agreements. $30. Yes, that's what it is what it is. But what are you guys filling in the blank? What is the time frame you guys are seeing? Life of the agreement. So that means there's no protection period. This is protection period for your commission, meaning after the expiration or termination of the seller brokerage agreement, your commission is still protected if they sell, generally speaking. 30 days, 60 days, 1 year, 60 days. Gotcha. Okay, I just wanted to get a sense of what you're doing. So if you put in life of the agreement, then there is 0 days protection period because the agreement would be terminated or expired and there's no protection for your commission. So, but let me tell you guys what that action, 180 days. Awesome. It's whatever you can negotiate or whatever your broker has as a policy. But I just wanted to get it. I wanted some interaction for you guys and just some information on this. So again, this is all described in this paragraph. The fill in the blank for the time frame is in the paragraph A5, and the legalese or the explanation is here in paragraph B5. I just want to talk about what this means. Basically, if the seller unilaterally terminates a contract, let me just go over here. It's easier just to do it this way. If the agreement is unilaterally terminated by the seller without the consent of the broker, remember I showed you guys there's a unilateral termination of brokerage agreement and mutual. If the seller unilaterally terminates, then the protection period is whatever number of days you have, 30, 60, 90, 180, plus the time frame that was left on the agreement. So basically, once a seller signs a listing agreement or seller brokerage agreement, they are tied into that contract. If they unilaterally terminate, if they want to quote unquote fire you, they are defaulting on that agreement. And you get to add, let's say you had let's say you had a 60-day protection period. They unilaterally terminated the protection period, and you still had a month to go on the original expiration date. Well, you get to add those 30 days. So now instead of a 60-day protection period, you have a 90-day protection period if it's unilaterally terminated. It also goes on to say that if it is mutually terminated, if the seller and the broker agree, you know what, this is not working, we are going to mutually terminate, then regardless of what you have filled in under the number of days for the protection period, it becomes a 0. There are no days of protection if a buyer and a seller agree to mutually terminate any kind of brokerage agreement. So you're not protected if there is a mutual termination. And the reason is on that mutual termination, there is a space to fill in the blank to negotiate any sort of compensation. Now, so how are you protected? How is your commission protected? So we've signed a listing agreement. The listing agreement has either terminated unilaterally, terminated because it expired. Again, mutual termination, there's no protection. So if it's terminated, if the seller, quote unquote, fired you and put that in writing, or the listing agreement has come to an end, if you put in, let's just use the 60 days. If the seller enters into a contract to sell or lease the property during the term or any portion of the property, which during the term of this agreement was submitted to, identified, or shown to any buyer, either in person or virtually, was provided specific information about or inquired about the property, either directly or through a broker working with a buyer, then the seller shall pay the broker at closing the commission. Oh, what does all that mean? That means that your commission is protected. If this listing agreement expires and then a buyer comes back and wants to buy the property, but it can't be just any buyer. It has to be a buyer that you can identify that saw the property while you had the listing agreement intact, or is working with another broker that showed the property while you had the listing intact. So here's a point of practice for you listing agents. If you have a listing agreement that is getting ready to expire, well, any listing agreement as you're going through it, y'all need to keep a list of the buyers that you show the property and the buyer's agents that access the property, the lockbox. In other words, it might be a good idea to get a lockbox that identifies who has accessed the property, like Supra does, versus just a combination lockbox. Then at the end of your listing agreement, if it has not sold, I would definitely provide that seller and keep in your records a list of those potential buyers in order to protect your commission if one of those buyers comes back and purchases the property during your protection period. However, here's the part that hangs up agents all the time. If the agreement expires, so the listing agreement expires or is unilaterally terminated, the moment that seller signs a seller brokerage agreement with another broker, there is no protection for your commission, regardless if you showed the buyer, or, well, if you show the buyer, you'll get the buyer side commission, but you're not entitled to the listing commission. So in other words, I have it summarized here. It's the wording of it is a bit complicated, but in essence, there is no commission protection for you, the former listing agent, the moment a seller lists with another broker, regardless of if you have filled in 30 days, 60 days, 180 days. Your commission is not protected if that seller sells, regardless if you showed the property or not, the moment they list with another broker. Now, this does potentially get into a discussion of procuring cause of sale, but that's above and beyond the scope of this class right now. All right. Then there is a section about agency and brokerage, which we have disclosed ad nauseum. Now, there are legally required seller disclosures. These are under the fraud laws in Georgia, which is OCGA 51-6-2, which says that the seller is required in the state of Georgia to disclose latent defects, even if they are selling it as is. And a latent defect is defined in Georgia by this law as a material defect that the seller has knowledge of and could not be observed by a buyer upon reasonable inspection. A seller agrees to complete but a seller does not have to fill out any particular form, but they are required by law to disclose a latent material defect as defined by law. So GAR does have two forms. They have a seller's property disclosure form and a latent defects and fixtures checklist. And those forms are designed by the Georgia Association of Realtors to help a seller not only, one, comply with the law to disclose a latent defect, but also provide other information about the property and the neighborhood that they have knowledge of. They're not legally required to disclose, to sign that and fill that out. However, the listing agreement states that the seller agrees to complete one of those. So if you have a seller, here's where this is all written out. If you have a seller that says, you know what, I'm not going to fill out the seller's property disclosure form or the latent material defects disclosure list. If they're not going to do that, that's fine. They're not legally obligated to fill out those GAR forms. However, they are contractually obligated to fill that out if you do not address it as a special stipulation that would say, that would say this would be your special stipulation. Per paragraph C1, seller will not complete a seller disclosure statement, but agrees to disclose in writing any known latent defects with the property, even if selling as is. So that is a point of practice for you guys. Your sellers are not legally required to fill out any specific GAR form or any form. They are required to disclose latent defects, but in the listing agreement, they agree to do that. So I would use that special stipulation if they don't want to do that. Now, there is another section on lead-based paint. If the property was built or anything in the property was built prior to 78, they are required by the EPA and by the contract to complete a lead-based paint disclosure at the time of signing. You guys, you've got to bring those lead-based paint disclosures and pamphlets with you when you go on a listing appointment or when you send documents for a seller to sign. You do not want to put your license in jeopardy. You do not want to put a seller in jeopardy. These are federal regulations per the EPA. And all of that is described here under paragraph C1. There are more sections. Ooh, what time is it? All right. There are sections on that limit the broker's authority and responsibility. And I'll show you where that is in the listing agreement. But basically, it does state that the seller acknowledges that you yourself, even though you have a client relationship with the seller, you may show it to buyers. You have no duty to inspect the house. The seller should seek independent expert advice on any matters of concern. The broker, meaning you also, owes no duty to the seller or have any authority on behalf of the seller outside of this agreement. Seller is responsible to duties and deadlines. There is an indemnity and a hold harmless agreement, and the broker has no authority to bind the seller to terms. All of that is described in paragraph C3. It goes on to say under limits of broker's liability, broker's liability is limited to the amount of the commission paid or $100 if there's no commission paid. If there is any loss of funds, seller funds via cyber fraud, the broker's limit of liability is $100. Note, I have a strong note here, you guys. I do not believe as of this point, spring 2022, that those statements have been tested in the Georgia courts. So don't hang your hat on if a public person's money gets stolen via cyber fraud, that your only liability is $100. There are previous court cases here in Georgia in the past where an agent had a much larger, I believe it was $80,000 financial liability because a public person's money got stolen by a cyber fraud due to no fault of the agent, but their email got hacked. And again, they ended up owing that public person $80,000. So GAR has put this in as a protection, but I don't believe it has been tested in the Georgia courts. Duty to arbitrate. If arbitration or litigation, the loser has to pay the winner's legal fees. And again, it is disclosed here as well as in the purchase and sale agreement. As I mentioned earlier, broker, as used in the forms, refers to the actual broker, you, the affiliated licensee, and the brokerage. Buyer and seller refers to the actual person signing the contract, or if it is an entity, the LLC. Any heirs, if the seller passes away, then their heirs or their estate is also bound by the contract. And then there is a section on fair housing. Fair housing laws apply. The seller, if there is a violation of fair housing laws, first of all, there are state fair housing laws. There are federal fair housing laws. There are license laws regarding fair housing violations. So it can have jeopardy to you and your license, but there are also legal ramifications statewide and federal. Point of practice. You guys, give your sellers the fair housing brochures. There are a ton of them available. There are national fair housing brochures. There are state fair housing brochures. I don't have it here, but Georgia has some through the Department of Community Affairs. Google fair housing pamphlets and you will find a ton of them. Just a brief description. We teach another whole class, 3-hour class on fair housing, but just A brief way, a quick way, I love mnemonics, a way to remember the federal fair housing protected groups. Just remember the mnemonic fresh corn. F stands for familial status. That has to do with being single, being married, having children, not having children, having adopted children, having foster children, so forth and so on. F is for familial status. R is for race, nothing for E. S is for sex, not a verb, but an adjective. H is for handicap or disability. C is for color, nothing for O. R is for race, and N is for national origin. So you'll see along the left side, if you go vertically, it says fresh corn. There's no E or O, just remember equal opportunity. The GAR, Georgia Association of Contract, adds sexual orientation and gender identity as protected groups. And if you are a realtor, the Realtor Code of Ethics also adds sexual orientation and gender identity to the protected groups. All of that is described here under paragraph C6. There's the fair housing disclosure and everything I just talked about. And then continuing under the miscellaneous section in the GAR seller brokerage agreement, it does state that the public is not required to use the GAR forms, and the courts may rule against any provision in the contract. Georgia laws prevail. Communication between a broker and seller is time sensitive. Seller gives consent to the broker to refer to another agent or another brokerage. There is a 2-year statute of limitations if there is a legal claim made against you or your broker. It's 2 years from the date of the claim. There is a survival clause, and in a seller brokerage agreement, the commission and the indemnity clause to protect you and your broker survives. And this is really, really important, and this is really good for you guys. There is a section that talks about third-party vendors, that you are providing third-party vendors as a courtesy. And let me show you where that is. This is wonderful. It is under the miscellaneous section in the seller listing agreement. It's also in the buyer brokerage agreement, but basically it says, broker may provide seller with the names of vendors to perform services on behalf of the seller relative to real estate transactions. In other words, a home warranty company, a closing attorney, an insurance company, a landscape company, a structural engineer, a roofing company, a termite company, blah, 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 blah. It goes on to say, broker does not warrant or endorse the performance of any such vendor, and the names of vendors are provided solely as a courtesy and starting point for the seller to identify possible vendors to perform services on behalf of the seller. A seller agrees to do his or her own due diligence regarding the services provided by these vendors. I do suggest you guys have got to keep everything in writing. GAR does provide a form F-834 called a vendor list. This is where I strongly suggest that you write out the name, type of vendor, phone number, or email address, or other contact information. I also point of practice, provide more than one contact for any particular vendor. If you're going to provide a home warranty company, provide at least 2 or 3. If you're going to provide a termite company, provide at least 2 or 3. But this goes on to say it is the same information. It says that you providing this list are performing a ministerial act as a courtesy, and it does not constitute any sort of warranty or representation of the quality of their work. And then there's a section on broker's duties and seller's duties. Your duty is to promote the property, to sell, present all written offers, disclose any known facts about the transaction, and keep confidences, but you must disclose any late material defects. The seller has a duty to refer all inquiries to you as the agent and make it available for showing, and disclose any adverse conditions of the property. That's all spelled out here. Then there's a section on default. What constitutes a seller default? If a seller defaults on a property, what that means is they owe commission. So default is defined in the contract if a seller unilaterally terminates a contract, if they default on a purchase and sale agreement, So in other words, they terminate a purchase and sale agreement, but the seller and the buyer go behind all the agents' backs and agree to mutually terminate and then do the deal outside of the brokers. So it's not a mutual termination upon a contingency or due diligence. It's the buyer and seller have gotten together, they're in cahoots, and they're like, hey, you know what? We can both save a lot of money. Let's terminate this purchase and sale agreement. You and I will get together. We'll go close it ourselves. They still owe both brokers, if there are two, commission. And there is a lot of agents who have been in business for a long time mistakenly believe that if a seller gets a full price offer on a property, they are obligated to sign a contract. That is not true. Dana, why is that not true? Again, as I said, don't believe me. Here is where that is all written out. And let me go back and tell you the circumstances under which they're obligated. They're not obligated to sell. Only a judge can order a person to sign a contract, and even then it might get contested in court. But they would owe a commission, not just if they receive a full price offer, but if they receive an offer that is full, that constitutes full price, excluding fees, commissions, and closing cost contributions. There are no contingencies, no due diligence, no warranties outside of what's in the seller's property disclosure statement, and the closing date is 30 to 45 days from the offer date. If that is what an offer looks like, the seller may owe a commission, but again, they're not obligated. That would constitute a seller default if they don't sign that agreement and go to closing. A seller default also is if a seller may owe a commission to a previous broker if they unilaterally terminated a previous listing agreement. If the seller defaults, the seller shall reimburse that broker any costs or withdrawal fees from the MLS service. Again, point of practice, y'all need to keep records and receipts of your costs, mileage costs, advertising costs, photography costs, so forth and so on. All of that is all spelled out here. May a seller terminate? Yes, but it must be in writing and signed by the parties. If not, the seller's in default. If you're under contract and you get quote unquote fired, you may be fired from representation. In other words, the client relationship, the fiduciary responsibilities might terminate, but you still might be owed compensation. Again, that depends on what agreements are signed upon termination and if it's unilateral or mutual. Again, as I addressed earlier, these are amendments that go with the termination of a brokerage agreement. There is an amendment where you can terminate it or change price or terms. You can extend it. Here is a unilateral termination of brokerage agreement. And again, a unilateral termination does not eliminate the seller's obligation to pay a commission. Mutual is signed by the broker and the client. You do negotiate costs and fees, and you agree to not sue one another outside of that. Here's what the unilateral termination looks like. And again, termination by the client or termination by the broker. There are situations where you as the broker, you as the agent, decide you are not comfortable working with that seller anymore or buyer, because these are just brokerage agreements in general, and you choose to terminate the relationship with the public. This is a mutual termination. This is a notice, so it's only unilateral, means it only requires one signature. This is mutual, so it does require the broker's signature and the client's signature, and you negotiate through any amounts that would be owed for the termination. There is a general warning of cyber fraud. You guys, cyber fraud is rampant in our industry among real estate agents, real estate brokers, closing attorneys, and lenders. Definitely, you want to warn your buyers and sellers to not trust any emails with wire instructions. And this is spelled out in the brokerage agreements and in the purchase and sale agreements. Do not trust any emails you get with wire instructions. You guys need to advise your buyers and sellers to cross-check and verify with a third-party source how to wire money. Don't email wire instructions from your broker, and do not email wire instructions from the closing attorney. Let the closing attorney deal with the public directly. Never put wire instructions in the subject line of an email. Send wire instructions via US mail versus email. And again, based on all of this and these preventions and this protection, if earnest money is to be wired, you want to negotiate for a longer time frame on a purchase and sale agreement for the buyer to remit the funds. Again, these are just some points of practice for you as the agent. Don't email wire instructions. Wire instructions should be delivered in hand by U.S. mail or analog fax, not an e-fax. Those get hacked too. Go ahead and get some wire instructions from your favorite closing attorney, from your broker, so that you can hand them to your public people when you first meet them. And then you will just confirm on the phone if they have changed. This is all spelled out there. And then there are a ton of consumer brochures. I strongly suggest that you get these brochures into the hands of your seller when appropriate, and you'll see into the hands of your buyer when appropriate. Let me cover, special stipulations. For example, as I've already mentioned, if a seller will not complete a seller's property disclosure form, then you're going to write out per paragraph C1, seller will not complete a property disclosure form, but warrants there are no latent defects with the property. If you negotiate for an early termination fee, you would probably write out seller may terminate prior to expiration of agreement by doing so in writing and paying broker an early termination fee of X amount of dollars. You guys, these are available for you as a handout, or what I suggest is take out your cell phone and take a picture of this screen so you can have these special stipulations, and remember to run them by your broker prior to using. There also might be a situation where you're going to negotiate your commission. So here's another special stipulation to consider in a seller brokerage agreement. That you're going to alter the commission if there's no other agent involved. Should no other agent be involved in the consummation of a transaction, at the closing of the transaction, seller to pay broker a total commission of blank % of the sale price. If you're going to do that, remember when you're filling out your MLS information, you want to put yes where it says variable rate commission or VRC. And if you agree to take a listing, but your professional opinion is that the seller is listing it too high, then you might want to add a special stipulation to the seller brokerage agreement regarding an automatic price reduction. For example, per paragraph A2A, should property not get an offer within 2 weeks of marketing commencement date, seller agrees that property to be marketed at a list price of blank, and that would be an automatic price reduction. And then there is an acknowledgement. This has been included in all of the GAR contracts, whether it be a brokerage agreement or purchase and sale agreement or lease, so forth and so on. Seller has read all the provisions and disclosures, seller understands, and seller agrees. And in the seller brokerage agreement, it does again state the seller is not subject to a current seller brokerage agreement. And then there is a place for you to sign it. Now, for purposes of notice, in a purchase and sale agreement, you might not want to include a seller's email address or phone number. But please, in these brokerage agreements, you guys, your brokers need this information. If something were to happen to you, let's say, I'm not going to go negative, we'll go positive. Let's say you're on vacation and you have no cell service, and the broker needs to get in touch with that client. The broker needs a way to get in touch with that client. So even though you might not include that information, like I said, in a purchase and sale agreement where the other party's broker has access to that, your broker needs it. All right, I'm going to go over the authorization to show unlisted property. I'm going to quickly go over the buyer brokerage agreement, and then we'll take a break because I want to get to a lot of the other contracts. But I spend a lot of time on the seller brokerage agreement because, you guys, that's what starts everything that happens with our business, right? If we had no houses to sell, none of us would have a job. None of us would be able to be of service to the public. If there was nothing to buy, which some of you guys are experiencing now, then you're working with a buyer, but there's nothing to buy. So that's why I spend a little bit more time on the seller brokerage agreement in the context of this class, because that's what starts everything that happens in our business right now. So the authorization to show unlisted property, it describes the seller's customer relationship with you as a broker. There's a lot of similarities in the actual agreement to the seller brokerage agreement, but it goes on and it specifically, well, it talks about commission, and it says the owner agrees to pay the broker at closing the following commission. There's no co-op information because you're not necessarily co-oping. This is just an agreement where the seller is the customer. Then it goes on to talk about no brokerage agreement. This is where it describes the customer relationship. This agreement shall not be construed to create a brokerage engagement between the owner and the broker, i.e. not a client relationship, but is rather limited to the owner's permission to give the broker, owner's permission given to broker to show property to prospective buyers and tenants pursuant to the above authorization in exchange for compensation to broker as set forth above. These parties understand that the owner is broker's customer and that as such, broker may perform ministerial acts for the owner. Now, you agents working with buyers, if you see, or the other way around, if you see on a purchase and sale agreement that a broker is working with a public as a customer, that does not give you permission to contact that public person and bypass the agent. The public person has still chosen the broker and the agent with whom to work with respect to a real estate transaction. It's just that the legal nature of their relationship is that of customer, not client. It is not permission to quote unquote cross assign. All right. I am going to cover the buyer brokerage agreement and then we will take a break. This section will not take as long because a lot of it is the same as far as commission. Protection period is a little different, so I'm going to cover that. But the commission, the broker's duties, all that kind of stuff. A couple of the things that are different is the commission section is a little different. Protection period is different. The buyer's duties are different. Buying a property sight unseen and exclusivity. You know what? 9:30. You know what? I think let's take a break. This is going to be a little bit more involved. I'm not going to be able to cover it as quickly as I thought. So let me stop my share. You guys ready for a break? Let's take a break. We will take a 15-minute break. All right. So welcome back, everybody, from break. And we are going to continue on with the buyer brokerage agreement and then some of the other forms. I will let you know that there are some mid-year revisions that GAR has made to the buyer brokerage agreements. So they are not included in the link that I have sent you or have made available for you for your handouts right now, but I will in the future. But the mid-year revisions just came out. So the information I have in the PowerPoint does not address those because the PowerPoint was created prior to that. But let me share my screen and we'll continue on. All right, so let me go back to the PowerPoint. And we are going to continue on. So, exclusive buyer brokerage agreement. Again, the highlights, I talked about that right before we went on the break, and let's get into it. It's going to take a little bit longer than what I was anticipating. So I just want to make sure to cover this. A lot of this information is very similar to the seller brokerage agreement, so I'm just highlighting some of the differences. Again, as I've mentioned, it has to be signed. There's the law that it talks about the client relationship. The term, agency, brokerage, commission, all that stuff is very, very similar to the listing agreement. Let's talk about commission. The commission is a little bit different. In the GAR buyer brokerage agreement, the way it is worded, it has a buyer obligation to pay a broker commission. The broker is entitled to whatever the buyer agrees to pay, minus any commission paid by the seller's broker or the seller. It also references the seller side commission paid will be listed in the MLS service. It used to say the seller normally pays commission. They've taken that verbiage out. I'm not going to get into it, but there is a ginormous lawsuit right now between the Department of Justice, National Association of Realtors, and then there's another lawsuit. I don't know if it's the same lawsuit or a different lawsuit against Keller Williams, Berkshire Hathaway, and RE/MAX that has to do with commissions, particularly buyer side commissions, antitrust. We get into that. I'm not an attorney. I'm not a judge. We do discuss that a little bit more in the contract dissection class. If you go to Google and Google all of that, there's a lot of information online. It is still an ongoing lawsuit, so there's no case law established regarding buyer side commissions. But GAR is attempting to be proactive to protect you, the agent, your brokers, and your public. So anyway, this is what it says in the commission section under the buyer brokerage agreement. Check with your broker's policies on the commission. If you put 0% or $0, just know that if the buyer defaults during the agreement or protected period, the broker is entitled to exactly $0. GAR changed the commission section in 2022 from a buyer option to pay commission to an obligation. The 2021 versions had buyer's broker deserves blank %, which is usually paid by the listing broker. If not, there was a checkbox that said buyer shall or shall not pay the difference. Additionally, GAR stated that you should not put $0 in the fill in the blanks. In teaching this class, this is a huge, okay, I'm not going to go over this right now, but again, as I mentioned, there was a big lawsuit going on. Check with your broker. You can Google it online. This is what we suggested at our brokerage at the beginning of the year. Don't put in $0 or $0, but put in a certain percentage of the sale price or a flat fee. And then on a transaction by transaction basis, you're going to do an amendment to the buyer brokerage agreement if you wish, and if your broker wishes, that after the buyer is under contract with a particular property, you would specifically identify the property. So for example, the amended buyer brokerage agreement would state at the closing of 123 Lucky Street, buyer to pay maximum or whatever realty, sorry, $0 as the brokerage will accept the commission of blank % of the sale price solely from the listing broker. Agents are supposed to never market their services as free to a buyer because they usually are not. Commission is included in the sale price and may be negotiated outside of the buyer and or buyer's broker, but has an impact on the buyer. That's the essence of the lawsuit. It's an antitrust lawsuit. I'm not going to go over all of that, but what I do want to show you is obviously we were not the only brokerage that had an issue with this commission section in the buyer brokerage agreement, because you are independent contractors, and if a broker can negotiate a commission with a seller, then they can with a buyer too. So this is the May 1st revision of the buyer brokerage agreement that GAR, Georgia Association of Realtors, just released this month. And under paragraph 4, well, a couple things. Let me show you one thing. First, they came up with a new special stipulation. Special Stipulation 110, new as of 5/1/22. Let me make this a little bit bigger so you guys can see it. I have a YouTube video called, a YouTube channel called Real Estate Made Crystal Clear. And I am getting ready to record a video. It's contract tips, license law tips, designed for any and all agents in the state of Georgia. And I'm getting ready to do a whole video on the mid-year revisions. But since we're on this special stipulation, brand new, it's pertinent to the buyer brokerage agreement. It would be a special stipulation to the buyer brokerage agreement. And it states, notwithstanding any revision to the contract contained in this agreement, brokers shall not look for buyer to pay any portion of broker's commission pursuant to this exclusive buyer brokerage agreement engagement. Again, check with your broker. This is what GAR has put out there as a point of practice. I want you to consider doing it the way that I have suggested, where you do it on a transaction by transaction basis, because in this market right now, we are experiencing a lot of sellers and listing brokers who are not paying commission. And if you do that as a blanket, if you do that new special stip as a blanket stipulation, you may not get paid anything. But additionally, in the May 1st release of the GAR contracts under commission, they have also added this verbiage that says nothing herein shall prevent the broker from being paid a commission in excess of the commission reflected herein, or from being paid a bonus if the same is offered by the seller or seller's broker. Buyer agrees that any commission to be paid by the buyer shall be shown on the settlement statement and collected by the closing attorney as a precondition to buyer closing on the purchase of real property, so long as the same is permitted by the buyer's mortgage lender, if any. Buyer and broker agree that the closing attorney may rely on this provision to collect and disperse any commission to be paid by buyer. So I just wanted to bring that out, that is brand new as of May 1st. So let's go back. Here we go. And then as addressed in the listing commission, it does talk about separate commission on a lease and a protection period. Now the extension, if the buyer goes under contract, same thing just with the seller. If the buyer goes under contract but terminates under contingency, then those number of days that they were pending get added to the end of the buyer brokerage agreement, but you must send notice, just like we discussed under the seller brokerage agreement. Now, the protection period, this is different from the seller brokerage agreement. This is that your commission is protected. If a buyer defaults by unilaterally terminating this contract, or at the expiration of this contract, if you have a protection period and a buyer, even if they sign another buyer brokerage agreement with another broker, that's where the difference is. You are entitled to commission if the property they purchase is one that you showed the buyer in person or virtually, or the buyer otherwise visited during the time your buyer brokerage was intact. So if your buyer brokerage agreement expires or is terminated, even if a buyer signs another buyer brokerage with another broker, if they go back and buy a property that you showed them, you are entitled to commission. If they sign a buyer brokerage with another broker and they go on and purchase another property that you had nothing to do with, it more than likely wasn't even on the market yet, you are not protected. Your commission is only protected on properties that you showed or the buyer saw during your buyer brokerage. So point of practice, you guys need to make a list of all of the properties that your buyer sees, whether virtually, in person, or you may have a case if you have a thorough discussion with them about it, if you do a buyer cash to close sheet, so forth and so on. But just buyers that they see online, even through a feed that you feed them, you might not be protected on. And that is all spelled out there. Under buyer's duties, it's very similar to the seller. It does state that they agree to work exclusively with the broker or agent if you've signed an exclusive buyer brokerage agreement. And it does state that the buyer is obligated to disclose to a broker if they have worked with any others or go back to properties that they've already seen. So the flip side of that is if you're working with a buyer and they say they've worked with another agent, or even if they don't tell you, but they go back to a property and you can tell by your interaction and conversation that they have seen that property before, you need to ask them if they've seen that property before, how they've seen that property before, because the buyer might owe that other broker a commission. And the buyer also agrees to not see for sale by owners without you, the broker. And that's all spelled out there. It does have, again, an exclusive agreement that they are not working with another broker. They have not, quote unquote, fired their other broker. They have not unilaterally terminated another brokerage agreement. So what if a buyer says, I fired my previous agent? Well, a broker, as I mentioned, may be fired from representation, but not necessarily compensation. License law states that the new buyer's agent, so if a public buyer comes up to you and says, I need your help, I want to buy a house, I fired my other broker. You, as the new buyer's agent, must confirm that per license law. You can't advise them how to terminate a previous brokerage engagement, and you don't know what special steps may have been included in that previous agreement. So what do? Well, you, again, this is protected. They are protected, and all of this is spelled out in our Beretta laws and under unfair trade practice laws, OCGA 434025B and 434025B 13 and 26. And what the license law states is if you have reason to believe a buyer or seller may have an outstanding brokerage agreement with another broker, in other words, you have seen this property before, or wow, I like it much better than the last time I saw it, or I fired my previous agent. That absolutely gives you reason to believe they may have an outstanding brokerage agreement. So if that's the case, you need to confirm per license law with the previous broker that the person has terminated that agreement prior to signing a brokerage agreement with you. So what do? You need to confirm that in writing with the previous broker or have a buyer's written affirmation. This is a form. Please check it with your own broker. This is a form we have come up with in our brokerage to help our agents comply with license law. And we have our buyers, typically it's the buyer side, buyer affirmation of termination of previous brokerage. If they do not give you contact information and you have no way of confirming that with the previous broker, I, buyer's name, affirm that I have no written obligation to work with any other broker for my real estate needs. All parties agree to indemnify and hold agent brokerage harmless, blah, blah, blah. And they sign that. All right. Whew. Continuing on with the GAR buyer brokerage agreement, where it talks about limits of broker's authority and other disclosures. It does, again, similarly to the seller listing agreement, it says if there's anything of concern to the buyer, it is their responsibility to investigate anything regarding the contract, the property, or the area, including, not limited to, getting a survey, checking for zoning, checking flood insurance, checking the school district, checking if there's any checking all of that. Again, I suggest you use the GAR consumer brochures. And again, this is a document that we use in our brokerage. Please run it by your own broker. You are more than welcome to use it, but please get your own broker's permission. We call this service recommendations, buyer service recommendations. It says, you guys, buyers forget. If there's money on the line, buyers forget. So in essence, what this says is a buyer signing that at the time they are working with you, it says there are certain recommendations professionally that you would make to the buyer. And the buyer says yes or no and signs it. So it says, for example, I choose to get a Georgia wood infestation clearance letter and bond. Yes or no? I choose to have the property inspected by an independent home inspector of my choice. I choose to get a home warranty. I choose to have it inspected for asbestos. I choose to get a survey. I choose to get owner's title insurance. I choose to have it rekeyed, so forth. And I choose to purchase the property with no blank contingency, so forth and so on. They sign it, you sign it. There's a hold harmless language. That way, if something comes up, as you've heard me say repeatedly, if you've taken my classes, nothing's an issue until it's an issue. They come back and say, well, you never told me to get a survey. You never told me to get owner's title insurance. You never told me the ramifications of purchasing a property without an appraisal contingency. You can whip out this form and say, yes, in fact, we did have that discussion and you chose to not do it. Here's where you signed, here's where you marked it, and here's where you signed it. All right, let me look at these questions before we go on. Based on what, do we have to amend the buyer brokerage agreement? Donna, I don't understand what you're asking. If you're the first buyer's broker or the second buyer's broker. So write a little bit more. And procuring cause of sale. So, okay, so let me go back to that. If a buyer has defaulted on a buyer brokerage agreement, so buyer has quote unquote fired agent number one, and they are now working with agent number two. Agent number two gets them under contract on a house that they actually saw with agent number one. So to answer the procuring cause of sale issue, agent number two, buyer's agent number two will get paid or is entitled to be paid the commission, the selling side commission from the listing side, because they would be, well, procuring cause of sale is a little bit more complicated, but generally speaking, they would have a good case to get paid the selling side commission from the listing agent. However, buyer's broker number one would have a very strong case to get paid the commission from the buyer. It is a breach of the buyer brokerage agreement, nothing to do with the purchase and sale agreement. So hopefully I answered that question about procuring cause. First, once you go under contract, you need to amend. It depends on how you do that commission statement. If you do, let's say in the buyer brokerage agreement under commission, you fill out this information here, and you say the buyer is obligated to put, and you put an amount in there. And this says an amount less minus what the seller is willing to pay. So let's say this has, we're not supposed to talk about commission. So let's say this has 3 apples. And let's say the property a buyer wants to buy, the seller side is only paying 2 apples. What this would say is then at closing, the buyer is obligated to pay 1 apple. It would be the 3 apples here minus the 2 apples the seller is paying. They would still be obligated to pay the 1 apple. What I'm saying is if you and your broker agree that you will be fine with just receiving the 2 apples the seller is paying, then after the buyer goes under contract, I would do an amendment to the buyer brokerage agreement that says at the closing of 123 Lucky Street, buyer's broker will accept the 2 apples that the seller is paying and will not require the buyer to pay the 1 apple. So I hope that is everything null and void if you let them out of the agreement? Yes. A mutual termination of brokerage agreement, there is no more financial obligation from the public person to your broker, and that you can negotiate for compensation on, I don't know if I have it here or not, on the mutual termination agreement. There is a place to negotiate for compensation, but that's when you would do it. All right. Also under the buyer brokerage agreement I hope I answered those questions. Also under the buyer brokerage agreement, brand new for 2022, in response to the market we're in, there is a whole new paragraph about the buyer buying a property sight unseen. And it just says that you as the broker and the agent advise the buyer there are significant risks to buying a property sight unseen. Pictures and videos don't do it justice, but they are agreeing to do that. So that again is protection for you. It goes on again to define a buyer as a buyer, buyer's family or entities, fair housing that we've discussed, GAR forms, all of this other information we discussed in reference to the listing brokerage agreement, seller brokerage agreement, and it's the same in the buyer brokerage. And then the default situation, again, where a buyer owes commission is the same. They only owe a commission, however, if you fill out a dollar amount or percent here. So again, you buyer's agents, if you're putting 0 there and a buyer defaults, they don't owe you anything upon default, even if they buy another property, because you have put in writing that your services are not worth anything, and a buyer is not obligated to pay you. Not that they're not worth anything, but a buyer's not obligated to pay you for your services. They are also in default again if they collude with the seller, if they unilaterally terminate and they go under contract and close a property that you weren't paid. So again, all of that is similar. I guess I could have covered that to the listing agreement. Now with the agreement to work, where the buyer is a customer, agreement to work with buyer as a customer, again, it does state that you as the broker / affiliated licensee are working with the buyer as a customer to only perform ministerial acts on behalf of the buyer. Now, different from the authorization to show unlisted property, there is no mention of commission in the buyer as customer form. So what is the difference? You guys, do you remember? This has been a long time from pre-license school for some of you, but do you know what the differences are between a client and a customer? This is spelled out again in our license laws. OCGA 10-6A, which are Beretta laws, describe brokerage relationships in real estate transactions. That's what Beretta stands for. And it talks about legal definitions, responsibilities to seller, client, buyer, client, customers, or transaction brokerage. I'm not going to read all through this, but if you do want to know what you are legally allowed, the interactions you are legally allowed to have with the public, if they are a client versus a customer, I refer you to look at this body of law, which describes specifically what and how you are to do when working with clients and what is defined as a ministerial act. Again, as I've told you, do not take anything for granted, but find out what is the source of an information any instructor or broker is telling you. And if you want to look it up for yourself, then go look it up for yourself. But it is available for you in the handouts, but this is where it is all spelled out. All right. Woo. Moving on. You guys hang in there. We got 45 minutes and we will get it all done. All right, so earnest money forms. Wait a minute, I'm going too far. All right. Closing attorney acting as holder of the earnest money, agreement of closing attorney to hold the earnest money, unilateral termination release, mutual termination release. So closing attorney acting as holder of the earnest money. I'm not going to go over this in depth. We do cover these a little bit more in our other classes, and there are some other different forms that a lot of times are not addressed in a class at all that I really want to get to. So basically, this is, there's two forms. One is an exhibit where a buyer and a seller sign identifying the closing attorney that's going to be the holder of the earnest money. The buyer has to get that to the seller. It has to get the contract, and the seller has to agree within 2 days after binding agreement date. If not, then the alternate holder becomes holder. What I want to bring to your attention, number one, 510 is the exhibit that buyer and seller sign. Then the closing attorney, the buyer must get F511 to the attorney to sign. The attorney must sign it within 3 days, or the alternate holder becomes the holder. So that's what I wanted you to know, number one. Number two, if it is an all cash transaction and the contract fails to close, and the buyer and seller do not agree on what happens to the earnest money, if a broker is holding the earnest money, the broker can do what we call the 10-day letter. The broker can go through the contract, find out, why did it terminate? Did one of the parties default? Did it terminate based on an unexpired contingency? And the broker, as the holder of the earnest money, can determine and disperse the earnest money, even in an all-cash transaction. If a closing attorney is the holder of the earnest money in an all-cash transaction, it terminates. You cannot get buyer and seller signature agreeing to what happens to the earnest money. The closing attorney is obligated to send that to court. You have now just created a lawsuit for your buyer and your seller over the disbursement of the earnest money. The closing attorney cannot do the contract interpretation and do the 10-day letter. They must go to court. Court fees come out of the earnest money, and the judge can award the loser to pay the winner's attorney's fees if the parties get an attorney. So think long and hard and have this discussion with your public people about a closing attorney as the holder of the earnest money in an all cash deal. All right. Now, let's talk about the termination and releases of a contract. A lot of you are familiar with what's called the unilateral termination and release agreement. It's called F522. Any termination, well, not the majority of terminations are unilateral, meaning either a buyer or a seller may terminate a contract. The disbursement of the earnest money is a completely separate issue from the termination of a contract. So you can have a terminated contract and still have a dispute over the disbursement of the earnest money. Just because buyer and seller don't agree on the dispute of the earnest money doesn't mean it's not terminated. Once you get a unilateral termination, if it's signed by one of the parties, it's terminated. If a buyer terminates a purchase and sale agreement, and even if the seller doesn't agree on what happens to the earnest money, the seller can turn around and put it back on the market. So termination on the unilateral termination release is unilateral. You must state the reason. You need both parties' signatures, however, agreement to disperse the earnest money. Again, if they don't agree, the holder may interpret the contract and send the 10-day letter, as long as it's not all cash and it's the closing attorney as the holder. I get a lot of questions about earnest money and termination and the timing. I want y'all to remember, if earnest money is addressed in the creation of a contract, it must also be addressed in the termination of a contract, even if it has not yet been sent by the buyer to the holder. So if, let's say you put in the purchase and sale agreement, buyer to remit earnest money to holder within 4 days of binding agreement date. Let's say on day 2, the buyer terminates the contract. You had a due diligence period and the buyer terminates a contract. On the release portion of the TNR, you still have to address earnest money. Regardless of where it is physically, it is still part of the deal, part of the contract. So all you would write is earnest money not yet remitted per the contract to be retained by the buyer. Now, one more thing on this. If, let's say, purchase and sale agreement, 0 days due diligence, but it has buyer to remit earnest money to holder within 3 days of binding agreement date. So there's a time frame for the buyer to send the earnest money to the holder, 0 days due diligence, buyer terminates a day after binding agreement date. The buyer is in default. So you buyer's agents, don't mistakenly think that that buyer's earnest money is not at risk just because they haven't sent it. Again, earnest money is still part of the contract, regardless of where it is physically. What does that mean? That means that the seller, the buyer has defaulted, and the remedy for default is the earnest money. And the brokers can pursue the defaulting party for commission. So if a buyer defaults on a contract prior to them having sent earnest money, the seller may pursue them legally for that earnest money, and the brokers may pursue them legally for commission. So just because they haven't sent it does not keep the buyer's earnest money safe. Just wanted to let you know that. Don't put 0 days due diligence. All right, now there is another form, GAR F519, a mutual termination release. Now, In essence, this is used as an out-of-court settlement agreement. The buyer signs it, the seller signs it, and both the buyer and seller, agent/brokers, also sign it. Because this has any amount of disbursement of the earnest money, but parts A and B have an amount if any of the parties are paying the brokers any money for this mutual termination. But here's what I want you guys to remember. It is only effective when it is signed by both buyer and seller and both agents/brokers. What does that mean? That means if you're working with a buyer and you are in, and let's say you do have a due diligence period and you are running up against the deadline of your due diligence period, and the buyer is deciding to terminate the contract to protect their earnest money, and they're going to go find another property for whatever reason. If that is the situation, you buyer's agents, you need to use the unilateral termination and release. If your buyer, if you are looking to protect your buyer's earnest money and you are up against a contingency deadline, you don't want to use this, because just because your buyer signs it on this mutual form, it is not terminated until all parties sign it. So just don't use this, again, if you're up against a deadline. And again, as I mentioned, the termination of a contract is different from the release of the earnest money. All right, even though on GAR they address them on the same form. All right, now there are situations where you buyer's agents, you are terminating. Let's say you're coming up to the end of your appraisal contingency time frame, and you've gotten an appraisal, it's come in low, and you're trying to fight the appraisal. Well, what some buyer's agents do is they're going to terminate the contract because you don't want to risk your buyer's earnest money, but you haven't heard back from the appraisal review board yet to see if you're going to get a higher appraisal. So you terminate the contract to protect the buyer's earnest money. Well, then you get the appraisal to come back at the contract sale price, and the buyer and seller agreed to go back under contract. Well, technically, you would need a whole new purchase and sale agreement. The problem is your lenders, a lot of your lenders can't operate on a new purchase and sale agreement. They have to go back to the one that was just terminated. This has been a huge issue. And 2 years ago, GAR came up with a new form called Reinstatement of Purchase and Sale Agreement. And this is really, in essence, because of the lending industry, and buyers were having issues with lenders not lending them on a reinstatement of a contract, because you really couldn't reinstate a contract without a lot of legalese. So this is a form 290, Reinstatement of Purchase and Sale. The buyer and seller may agree to reinstate a terminated contract. You have to get both of them to agree. Many lenders require this rather than writing a new contract. Make sure to address earnest money that will stay in the deal, or was it dispersed upon the termination? So a lot of this depends on the timing between the termination and the reinstatement. And this is what it looks like. Agreement to reinstate a contract. You fill in the buyer and seller's names. It does say the agreement was terminated. They are agreeing to reinstate. There is a fill in the blank section, but this fill in the blank section is not designed to be an amendment to the contract. You would put, basically, the contract falls back into existence exactly where it was, with the following changes. Changes might be, for example, any time frame changes for contingencies, what happens to the earnest money if it stays with the holder, if it wasn't already dispersed, a new closing date, so forth and so on. And it is required to be signed by both buyer and seller. Financing and appraisal forms, I'm not going to cover that at all. That's going to be another hour discussion, and we do cover those in depth in the contract dissection class. Generally speaking, do not leave the number of days for any contingency time frame blank. Does that mean it's 0 days, or does it go through the length of the contract? Only a judge would decide. My broker interpretation is that it goes, if a time frame is left blank, it would go through the entire length of the contract. But I've done a video on that. Just don't leave any blank time frames. Contract disclosure forms, again, I just want to bring these to your attention. They are covered more in depth in our contracts dissection classes, as well as the community association disclosure. Again, the purpose of today's class is to cover some forms that are not really addressed in any other contracts class. So we're going to continue on. Sale, and I want to get to some special stips, especially this appraisal gap stip you guys are having to contend with right now. Sale or lease of property contingency exhibit, GAR F601. Basically, this is a buyer that has a current house, and they have to sell or lease their current house before they are able, either wanting to or financially qualified to purchase the new house. So this is the form you use. The form, this was updated last year or 2 years ago, I don't remember now, and it gives a seller a lot more control if a seller is going to choose to take this as a contingency from a particular buyer. I know today's market, there are a lot of contingencies, but you need to understand this because the markets are cyclical. Basically, the buyer identifies the current property that they own, and the buyer warrants that either it's listed and you identify the broker with the listing, it's under contract, and you fill in the name of the broker that represents the buyer of their current home and the closing date, so forth and so on. The contract for the new house is contingent upon the buyer selling or leasing their current home on or before whatever that time frame is. You fill in a date, and that is considered the contingency period. If their current home does not sell by that date, then the contract for their new home automatically terminates, and the buyer will get their earnest money back. You guys need to pay attention to these time frames and the fact that there's automatic termination rights spelled in, written out. If the property was under contract and if their current home was already under contract and that contract falls through, the buyer is obligated to notify the seller, I had it under contract, but it fell through. And then the seller now has termination rights with this buyer for the new house. Again, all of that is written out and spelled out in this sale or lease of property contingency exhibit GAR F601. And this is where all of that information is spelled out. I just, again, want to bring to your attention a lot of, without going over it point by point by point, a lot of the content of what is in here when you are signing this exhibit, especially with obligation rights and buyer and termination right, termination rights and earnest money rights and timeframes. There's also a kickout clause, meaning the seller can say, okay, buyer, I'll go under contract with you to buy my house. I understand you have to sell your house first, but you allow me the right to continue to market my property. And if I get another offer that I want to accept, I have to come back to you first, and I'll either stay in contract with you if you remove some contingencies. If you're not able to remove certain contingencies, then I'm going to terminate with you. You'll get your earnest money back, and I'm going to go on with buyer number 2. All of that is spelled out and explained. It's the kickout clause, and it's explained here. And here are the various contingencies that the buyer and seller agree to keep in or remove should the seller exercise the option to kick out the buyer. If the seller agrees that the buyer, to give the buyer time to sell their current home. If, oh no, this is if they decide kick out and they can't remove the contingencies. All right. Backup contingency exhibit. See, I don't have a picture of the whole thing. Backup contingency exhibit. So if a seller is under contract with a primary buyer, but they want to go under contract with another buyer, you would sign a backup contingency exhibit. So you would negotiate the full contract and include this exhibit, GAR, Georgia Association of Realtors, F604. You have to identify the name of the buyer on the primary contract and the binding agreement date of the primary contract. What does this mean? That means that you buyer's agents, if you're talking to a seller and they say, talking to a listing agent, and they say the seller is under contract and has a lot of backups, that's not true. You can only have one binding backup exhibit. They can have a lot of interested potential buyers and a lot of offers that the seller had looked at, but you can only have one binding backup exhibit. It is an exhibit to a specific binding contract, and as I mentioned, you do have to reference the primary buyer. If the primary buyer gets terminated, the seller sends notice to this buyer, buyer number 2, that they are now primary. That is day 0 for the timing of all other contingencies. What does that mean? If you are working with a buyer and you have a binding backup contract, you negotiate everything, you include this exhibit, you have a binding contract. The buyer is binding in backup position for this house. So the binding agreement date is the date the buyer and seller signed the contract with this exhibit. Earnest money is due from that date unless you specify other words in a special stipulation. However, all of the other timeframes, due diligence, financing contingency, appraisal contingency, those timeframes only kick in when the backup buyer gets a written notice from the seller that they are now primary. That becomes day 0. It's not the binding agreement date. You're already binding. That just becomes day 0 for counting purposes. Prior to being made known that they are primary, the buyer may terminate and they will get their earnest money back. So here are some notes. There may only be one backup contract. Absent any special stipulation, the backup buyer's earnest money is due to the holder based on the agreed upon time frame on page 1 of the purchase and sale agreement. For as I just mentioned, other contingency timeframes, day 0 is when they get notice. All right. Then there's a general contingency exhibit. This would be, there are other contingencies that buyers and sellers agree to. I just wanted to bring this to your attention that this is available. It has kick-out information, just like on the sale or lease contingency exhibit, but this would be for other contingencies. All right, let's finish up our time by half an hour. Let's talk about special stipulations. So you want to limit them as much as possible. So there is a, hang on one second. There is a whole library of special stipulations in the GAR contract package and in the RE forms contract package, and your broker or other classes might supply other special stipulations as I'm supplying with you guys here. If you are, whatever special stipulations you get from any class, you definitely want to make sure to run them by your broker and get approval to use them in a contract. So you do not want to write a special stipulation that addresses an issue already covered, because a special stipulation supersedes or takes precedence or controls, you've heard all of those words, over anything else that's written in the contract. A special stipulation takes control over an exhibit, which takes control over the contract, and an amendment takes control over a special stipulation. So what do I mean by don't want to address anything that's already covered? Well, let's say that you are working with a buyer, or you're on the seller side even, and the buyer is getting a loan. Let's say they're getting a conventional loan, and part of the contract includes the conventional loan contingency exhibit. And so you have an exhibit, and then let's say the parties agree to a special stipulation that says This agreement is contingent upon buyer getting a loan from the lender, period. Well, you absolutely would not want to use that as a special stipulation because that is already addressed in the exhibit. So why would you not want to say that? Well, your stipulation supersedes that exhibit. And a lot of times your special stips, when you write them like that, are not complete. For example, well, what happens if they don't get financed by the lender? Well, I don't know. You didn't write that in. And you're thinking to yourself, well, gosh, dang, it would just go back to the exhibit. No, it doesn't necessarily go back to the exhibit because you just superseded that exhibit by writing this stipulation. A lot of times you guys are writing your appraisal gap contingencies. Your appraisal gap contingencies, a lot of them are horrible. And you guys are writing, should property not appraised for contract sale price, buyer agrees to bring $5,000 above low appraisal, not to exceed sale price. And that's where you leave it. And then so what happens if the gap is more than $5,000? Let's say you write that as a special stipulation, and don't worry, I'm going to give you a good appraisal gap stip. What happens if you write that as a special stipulation, but the gap is $7,000? The appraisal is $7,000, $8,000, $10,000 less than the sale price. Well, the buyer has only agreed to bring $5,000. You're still short. Let's say you're still short $2,000 from the sale price. What happens? Well, I don't know. You guys didn't put that in there. Is the seller obligated to come down? Absolutely not. The buyer said they're going to bring the contract sale price to the property. Is the buyer obligated to bring that additional $2,000? I don't know. If it terminates, who's in default? Who gets the earnest money? I don't know. Y'all did not address that. So really, really, really limit your special stipulations and do not address something that is already addressed elsewhere in the contract. If you do write a special stipulation, make sure to address if a backup, before I go on, let's see, if a backup agreement automatically terminates and the earnest money was received, is a TNR still required for the disbursement of the earnest money? Yes. So there are certain contingencies, there are termination rights pre-printed, written into various contingencies where a contract will automatically terminate, especially like on an FHA or VA loan. There's a lot of automatic termination verbiage written in those. And in this situation, yes, if a backup or even a sale or lease contingency automatically terminates, the termination is there. But as I addressed earlier, termination of a contract and release of the earnest money are two completely separate issues. The problem is GAR has put both of those separate issues on one form. So regardless of a termination, even if an automatic termination is built into the contract, you still need some sort of documentation and written agreement with signatures by the buyer and the seller regarding the disbursement of the earnest money. So yes, that is my long-winded answer to answer your question. Yes, if there is an automatic termination right built into a contract based on some sort of contingency and time frame, then you will still, buyer and seller will still need to execute the quote unquote TNR to agree to the disbursement of the earnest money. Great question. All right. If you write a special stip, make sure to address what the issue is, how one party will give the other party notice, what is the time frame, what are the consequences for the party's lack of performance. In other words, if they don't do what they said they were going to do, what constitutes default, is there a time frame to cure that default, then a time frame to the termination, and most importantly for your public, what happens to the earnest money? For example, let's say a seller needs to act before a buyer may proceed. For example, seller needs to turn on the utilities, or a seller to complete a community association disclosure. You don't want to start a buyer's due diligence period when they do that, because a buyer won't ever be able to terminate. So let's say the seller needs to turn on the utilities, and they're going to have to do that before you want your buyer to spend money on an inspection or an appraisal, so forth and so on. Let's say you had a 10-day due diligence time frame. Well, you don't want to write Due diligence to begin when buyer receives written information from seller that all utilities are on or operational. Because what happens if you never get that from the seller? Can the buyer terminate? No, you haven't started due diligence. So if a buyer terminates, but you never get information from the seller that the utilities are on, and your buyer terminates, your buyer's just defaulted on the contract because you're not in due diligence if you write it that way. So here's how you need to write it. Buyer's due diligence period to begin upon binding agreement date. You buyer's agents, you always want the due diligence to start when you go binding and extend for blank number of days, 3 days, 4 days, 10 days, whatever. Buyer's due diligence period to begin upon binding agreement date and extend for 4 days after buyer's written receipt of, for example, notice that all utilities are on or operational. Then what happens is if you never get that from the seller, your buyer can terminate and will get their earnest money back. If you do, let's say you initially put, let's say you put in 4 days after buyer's written receipt of notice that all utilities are on or operational. Let's say you get that 10 days after binding agreement date. Well, then your buyer now has 4 days to have inspections done or terminate, so forth and so on. So they haven't paid for an inspection that the inspector goes out there and there's no utilities on. So again, you just want to protect your buyer's earnest money. Again, do not start a buyer's due diligence upon receipt of the thing, or the buyer won't be able to terminate and protect the earnest money if the seller never acts. Appraisal gap. Okay, this is such a big deal right now. Make sure to address what happens if there is still a gap, as in my previous example, between the cash the buyer is willing to bring and the low appraisal and contract price. Rights to negotiate, termination rights, what happens to the earnest money. If you don't address these issues, there's nothing that is an automatic given. The seller is not obligated to automatically come down to a low appraisal, plus the cash the buyer is willing to bring. So a lot of agents mistakenly think that, again, if there's still a gap, that the seller will be obligated. In my previous example, buyer says they're willing to bring $5,000 over a low appraisal, not to exceed sale price. If the appraisal comes in and it's $7,000 less than the sale price, the seller's not obligated to still come down to that $2,000. Buyer's not obligated to come up that $2,000. You have to address that. Also, you buyer's agents and actually you listing agents, you want to make sure that the buyer has that cash. So depending on the amount of gap money they're willing to bring, you listing agents might want to counter offer and ask for proof of funds for that cash. You need to make sure that the buyer has the cash for their down payment, prepaids and escrows that's obligated per their loan, plus the additional cash to fill the gap. You also want to make sure to cap this amount that the buyer's willing to pay. And, oh, I'm sorry. Those are just some things. I'm going to show you guys some specific appraisal gap stipulations in just a minute. I just want you to think through some of these issues. Escalation clause. That's when a buyer says, I am willing to pay X amount of dollars over the next highest price. You want to make sure to cap that. So you want to say buyer is willing to pay whatever, $1,000 over next highest offer, not to exceed a cap amount of $625,000. And you need proof of the next highest offer so that a seller doesn't say, yeah, my next highest offer was $600,000 when their next highest offer was really only $550,000. Repairs, you guys, repairs are such a huge issue. And on these amendments to address concerns, y'all are not addressing what the buyer and seller during a due diligence period or right to inspect contract, you'll put seller to repair or replace, blah, 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 blah. Well, what happens if they don't do it? Can the buyer terminate? No, not necessarily. Termination is not necessarily a remedy for a buyer should a seller breach on repairs. There are several, at least one that I know of, court case in Georgia a few years ago where that was proven to be the case. So buyer termination rights, if a seller doesn't perform, especially repairs, isn't necessarily an option. So you need to address what happens should a party not perform, especially with repairs. A good way to think about handling it is avoid many issues by handling repairs financially. Either a lower sale price, an increase in seller contribution to buyer's closing costs, or a special stipulation that reads, at closing, from seller's proceeds, seller to pay X amount of dollars to name of a vendor, roofs are us, handyman are us, and you write it that way. That way, it doesn't involve the lender because it's not a contribution from a seller to a buyer. It is the seller paying money directly to a vendor. But at closing, the closing attorney writes a check payable to the vendor, but physically hands that check to the buyer. And the buyer can then schedule the vendor, will supervise the activity, will have all the receipts, all the warranties, can add on to the services, so forth and so on. So again, what if a seller fails to complete negotiated repairs? May a buyer terminate? Not necessarily. You need to address these issues on the amendment when you negotiate for repairs. Here's one way to do that. So you're on the amendment to address concerns. You said seller to fix blah, 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 repair blah, 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 replace blah, blah, blah. Then you're also going to add, all parties agree that the repair work contemplated and agreed upon herein shall be completed not less than 3 days prior to the closing dated of whatever. Don't leave it to the closing date. You don't want to have to deal with this stuff on your walkthrough the morning going to closing. You want plenty of time to negotiate through any of this stuff. All work shall be completed by vendors licensed in the state of Georgia through the proper state licensing board to complete the work required herein. Seller shall provide to buyer at least 3 days prior to closing evidence of vendor's license to do repair work, invoices, and paid receipts for all work completed. Should seller not complete the work required herein at least 3 days in advance of closing, buyer shall have the right to either, one, immediately hire vendor of buyer's choice and have work completed at seller's expense to be paid at time of closing from seller's proceeds, or two, terminate the contract agreement with full refund of all earnest money deposits. So that's one way to address it. Here's another way, and this stipulation is from the RE forms library. The parties agree that the repairs seller has agreed to complete under the contract may not be complete as of the date of closing. In that event, no later than blank days after closing, seller shall complete all repairs to the property agreed herein. It is understood and agreed that the seller, in showing of good faith, shall deposit at closing X amount of dollars with blank, either one of the brokers or the closing attorney, as security for the completion of said repairs. As long as the seller completes or causes to be complete all repairs no later than midnight of the repair completion date, the repair fund shall be returned to the seller within so many days of the repair completion date or the submission of proof of the repairs to the buyer. If you're going to do that, I also suggest you use GAR has an escrow agreement, F513, and you complete the form to reflect the terms of escrow for the repairs. Here are other repair special stipulations from GAR. Seller shall not be obligated to pay more than X amount of dollars for the following repairs and replacements. Buyer shall be obligated to pay any costs in excess of said amount. At or prior to closing, seller shall provide buyer with copies of paid invoices to verify seller has fulfilled its obligations hereunder. Again, even GARS is incomplete. As a broker, I've dealt with this many times. You need to put what happens should the seller not fulfill their obligations. So again, just like in this one, you would put, should that not happen, buyer has the right to either basically have the money deducted from the seller's proceeds or terminate. Now, down payment assistance, you buyers working with, you buyers agents working with buyers that have to get down payment assistance funds. You need, if they get denied their down payment assistance funds from like Georgia Dream or one of the other programs, they are not, their earnest money is not protected under the financing contingency. The financing contingency does not protect earnest money should the buyer not have their down payment, regardless of where they're getting them from. So you buyer's agents, if you're working with a buyer getting DPA, down payment assistance, you need to add a special stipulation. This agreement is contingent upon the buyer's approval for the receipt of down payment from blank program within so many days from the binding agreement date. Should the buyer not be approved for down payment assistance program within this time frame, buyer may terminate without penalty if the buyer notifies the seller in writing and provide the DPA denial letter. Termite letters, these are in GAR. These are some GAR special stipulations about getting a termite letter and a bond, retreat bond or repair bond. Repeat or repair bond. Home warranty. At time of closing, seller shall provide buyer a home warranty issued by blank company at a cost to seller not to exceed blank amount of dollars. The term of this home warranty shall be at least 1 year from the date of closing. Home warranty to be ordered by whichever agent, and this provision shall survive closing. You especially want this verbiage here because if for whatever reason it doesn't get ordered at time of closing, if you do not have this verbiage, this provision shall survive closing, and you close without it, the seller is no longer financially obligated to purchase that home warranty for your buyer. So guess who's going to be buying a home warranty? Clean copy. This is when a buyer and a seller go binding and with a counter offer. So the buyer writes an offer to the seller and they go back and forth with counter offers, and your final terms binding upon the parties is the original offer signed only by the buyer plus whatever counter offer is signed by buyer and seller. So a lot of lenders and brokers and closing attorneys and your public people, it's too much to make sense of. So you can do what's called a clean copy or a conformed copy. In other words, you pull out an entire blank purchase and sale agreement and you write it up that reflects the terms the parties had agreed to with the counter offer. On that conformed copy, you're going to want to add this GAR special stipulation. Buyer and seller acknowledge that the above agreement is a conformed copy of an agreement between the parties dated whatever the original date was. In the event of any conflict between this conformed agreement and the original thereof, all parties agree that the original shall control. In other words, if you've made a typographical error in closing costs or sale price, just because the parties have signed a clean copy does not change the actual terms they agreed to. How do you get access to the RE forms? Wherever you get access to your GAR forms, whether it be through Remind Docs Plus and FMLS, Transaction Desk in Georgia MLS. For you agents with brokers that have .loop, some of your brokers have only uploaded the GAR forms. You as an agent have access to the RE forms are free, no cost to agents in Georgia, and they are available. Again, other MLSs, you'll have to ask them. I'm just familiar with Georgia MLS and FMLS. And they are available to any agent for free when you go into Docs Plus and FMLS and again, Transaction Desk and Georgia MLS. You guys, there are a ton of other contracts available to you there. There are Alabama contracts for you agents licensed in Alabama. There are Fannie Mae contracts available especially in they might be in FMLS now too, but they are in Transaction Desk for you guys dealing with Fannie Mae properties. There are a ton of other contract forms available to you, but that's where you can find them. Survival. This provision shall survive closing. You might want to add that special stipulation that legally basically states that a party's responsibility to perform contractually exists even after the closing date. Again, I mentioned this at the beginning, there are a lot of complexes that are not approved for FHA or VA financing. So you buyers agents working with buyers looking especially in a condo or townhouse complex, you absolutely need to add in to protect the buyer's earnest money this special stipulation. Notwithstanding any other provision to the contrary, if it is determined the property is in a real estate development that is not FHA or VA approved, buyer may terminate this agreement upon notice to the seller and receive full refund of earnest money. Amendment to address concerns. You guys, This is the only amendment that has a time frame in it. And basically what it says, and GAR added this a couple years ago, if this amendment does not become effective during the due diligence period, it shall become null and void and no legal force in force. What does this mean? This means a couple things. I just had an issue yesterday, actually, with two separate agents. You buyer's agents, the due diligence time frame is a drop dead time frame for a buyer to terminate a contract or continue on. If the buyer and seller are negotiating through repairs and you are coming to the end of a due diligence period, an outstanding amendment to address concerns does not extend due diligence. Even if, let's say, a buyer has sent an amendment to a seller to address concerns. Let's say a seller has initiated a counter amendment back to a buyer to address concerns. If you do not have one document with both buyer and seller signatures on it before the end of due diligence, your buyer has now just purchased the property as is. If buyer and seller still agree to do those repairs, but it wasn't signed before the end of due diligence, y'all need to completely pull out a general amendment and rewrite all that information, because nothing on this amendment to address concerns is binding or enforceable in the contract if it does not have both buyer and seller signatures before the end of due diligence. Again, this is the only amendment in the GAR contract package that has a time frame, and that time frame coincides with the due diligence period. Similarly, regarding that, if it is a make it or break it issue for a buyer and they just cannot buy the property if the seller doesn't repair something, then there is an option. Then you will want to add a special stipulation that says, in the event that a subsequent amendment to address concerns with the property is not accepted by seller and delivered back to the buyer prior to the end of the buyer's right to terminate as set forth in the due diligence provision of the agreement, said amendment to address concerns with property shall serve as notice of termination of this agreement upon expiration of the due diligence period. Then you would follow up, as we've already mentioned, to get the earnest money back. So again, you're only going to use that special stipulation if it is a make it or break it form, like a make it or break it repair, like a roof or structural foundation, because if it's an open amendment, does not extend due diligence, and you need to protect your buyer's earnest money should they choose to terminate. If you are using an amendment to change the closing date, GAR F716, pay attention that there is a verbiage in there that the buyer and seller negotiate if the right to unilaterally extend for 8 days is still part of the contract or is terminated. And you guys, that's just a GAR contract provision. That's not a law in Georgia. No party has a right to unilaterally extend a contract unless they have agreed to it or contracted for it. Amendment to the sale price. If buyer and seller can agree to change the sale price for any reason, for example, as I mentioned, instead of negotiating for actual repair work to be done, sometimes you just want to change the sale price. So you would use this amendment. If you're using this amendment to change the sale price based on a low appraisal, then you need to attach a copy of the appraisal. If you're lowering the sale price, again, in lieu of repairs, you just state the new sale price. You never include the phrase in lieu of repairs. That's going to raise a huge red flag to your lenders. Other amendments, there is a general amendment to the agreement. And again, that's what you would use if buyer and seller do agree to negotiate repairs after the end of due diligence. There's an amendment to remove a contingency, amendment to remove the sale or lease contingency. There's a general notice form. Let me finish up with this temporary occupancy agreement for the seller. In our market, I know we're coming close to the end, so hang with me for just 2 more minutes. In this current market, there are a lot of buyers that are giving sellers the right to occupy the property after closing. What I want to bring to your attention, in the GAR temporary occupancy agreement for the seller after closing, GAR form F219, there is nothing in that agreement about the seller paying the buyer for the privilege of staying in the property. There's no quote unquote usage fee. In the RE forms, occupancy agreement for seller after closing, there is a usage fee. It does state, so this verbiage is from the RE form. This is not GAR verbiage. It does state in the RE form, seller shall pay buyer at closing the usage fee in the amount of X amount of dollars, basically for the privilege in staying in the buyer's new home for a certain number of days. So the GAR temporary occupancy agreement is better for sellers because there's not additional payment to stay in the property. RE form is better for buyers. That just something to keep in mind. And commission instructions, GAR F255. It does, as you guys are familiar with, have commission paid from the seller to the listing broker and from listing broker to the buyer's broker. If you guys are rebating any part of your commission back to one of the parties or paying for a home warranty, that is all itemized on page 2 of the instructions to closing attorney. There is another form that GAR has out there. It is GAR F258, co-op commission agreement to be used prior to showing. If you are working with a buyer and your buyer has found a property that they're either buying sight unseen, but there's another broker involved, it's not in MLS, it's new construction, so forth and so on. You buyer's agents, y'all need to protect your commission. There's no promise of commission if there's nothing in MLS. So avoid any misunderstanding about commission before you show a property or write an offer by using this co-op commission agreement. And it specifically states to be used prior to showing. It's GAR form F258. Here are some other offers, and again, we are at the end, but I just wanted to bring these to your attention. These notes are available for you to download. There's withdrawal of offer, rejection of offer, request for confirmation, bill of sale for personal property items that in essence is a receipt between the buyer and the seller. You guys, a bill of sale is not necessarily part of the contract. It's just a receipt between the buyer and the seller. Some other forms just to bring to your attention, there's a reminder of important dates. Great form after you go binding to share with your client and your co-op agent so everyone's on the same page. There is a contract checklist. It says it's for a broker, but this is a great form to keep you agents on track of everything that you need. Transaction checklist and contract review. There's an estimated net sheet to a seller, an estimated cost to close for a buyer, vendor list, we've already talked about that. Broker information disclosure. If you get asked a question about the property, it has a place where you can put in writing what the question is, what the answer is, and the source of that answer. Tons and tons of consumer brochures. I suggest you use all and any. There are a bunch of consumer brochures in the RE forms contract package as well. Oh, we made it. So again, I just want to keep this slide up just for a minute. As I've said repeatedly, please confirm all contract questions with your broker or closing attorney. Please attend additional courses. This is where you can find additional courses that we have. Register for reclasses.com. They have different geographical areas, or you can select Marietta for a full list of all the classes, including the virtual classes. There is my YouTube channel, Real Estate Made Crystal Clear, where you can see tons of video tips on the GAR forms contracts, the RE forms contracts, license law. And again, that is where the handouts are available. If you need to leave, you are more than welcome to leave, as you guys are doing now. Please, one more time, type in your name, real estate license number, email address, and phone number. I will stay on to answer questions. Because everybody is typing in their contact information, if you want to ask a question, feel free to unmute yourself and ask your question, but please mute yourself back when you are done so others may hear the question and the answer. I thank you guys so much for your time and attention. I hope I achieved my goal that number one, the 3 hours went by very quickly, and number two, that you learned some things or were able to think about some of these issues prior, in such a way that when you're in the heat of the moment, you can kind of think through something rather than having to memorize something or just fill in some blanks. But I'll stay on and answer any questions anybody has. Any questions? No questions?
Hi, Dana. Deborah Miller.
Hi, Deborah.
Again, you said I don't belong to a board, and I can get the forms, the RE forms and GAR forms from where I know I have to pay for a code for the GAR forms.
So for GAR forms, if you're not a member of a board, you can pay GAR directly, and you would go to GAR's website and you get what's called a forms purchase ID number. Then you hook up with your MLS service, you enter in, it's under profile or preferences. You enter that in and you'll have access to the GAR forms. The RE forms are available to agents without having to pay anything in the Remind Docs Plus section of FMLS and in Transaction Desk in Georgia MLS. If you are a member of any other MLS, you'll have to contact them directly, because I don't know where. I would imagine also through that MLS service, but I'm not familiar with those other MLSs.
Okay, thank you.
Yes, ma'am.
And the course was great. I think this is the second one I've taken with you, and I'm sure I'm going to take more because my license renewal comes up next year. So awesome. I'm trying to get all of this in now.
Terrific. Well, I'd love to see you. Thank you, Deborah. All right, anybody else? This was a lot of information, wasn't it? This could be a whole year-long course. And again, that's why I share with you guys my YouTube channel, because basically I do anywhere from 10 to 20-minute videos on each one of these topics where you get a little bit more information.
Dana, can you hear me? Curtis Smith?
Yes, sir, I can.
Oh, okay. Doesn't seem like my chat is working there. And I want to sign off. Do I need to sign off?
Yes, sir. What is your license number?
316158.
And what is your email address?
curlyq6@gmail.com. And I signed after break there, but I don't know if it registered. It just says to everyone, but it doesn't actually go up in the other part of the chat.
If it says to everyone, you might not see it yourself, but I have you in and I have noticed you have it on, so I will type it in the chat for you.
Okay, and it's Curly Smith, 678-576-1269.
Okay. Hang on one second. Okay, tell me your phone number again, 678?
678-576-1269.
Yes, sir. All right. Thank you so much. Got it.
Thank you.
My pleasure. Bye. Anybody else? All right. Well, thank you guys so much. I appreciate your time. Please continue to be a blessing to your buying and selling public. They still need you out there. Buying and selling a house it is business, but it also can be very personal and very emotional. And there has always been, and there will always be a need for real estate agents within these transactions. And you guys continue to be a blessing to others with their real estate needs by the means of your real estate license. Thank you guys so much. I appreciate your time and look forward to seeing you in another class. Bye-bye.